In the last session of Chapter 9 Leasing, we had a look at certain important clauses as well as what are the problems that come into the issue of leasing. While leasing is extremely useful to be utilized, especially in high technology, low volume products, however, things like maintenance, insurance, asset return, asset agreement of the foreign country, all these issues come into being. All of them can be mitigated to a certain extent, and possibly certain provisions can be added into the chapter, which improves the way we can apply leasing to defense products. Now we shall come to session 2 of the chapter, where we will look at the leasing process and the condoning powers towards various delays that may take place. In the flow chart for this particular issue of leasing, the first step is the request for information. Now, whenever the product is being sourced from a foreign OEM, a letter of interest is issued out instead of a request for information. Letter of interest, LOI, is issued to the OEM government as well as to the OEM. Now let's have a look at what RFI encompasses. The LOI would also be on the same line. Now the RFI is published on the MOD website. Obviously the LOI is not published. LOI straight goes to the OEM and the OEM government. The copies are forwarded to the industry representative bodies, the CII, ASSOCHAM, FICI, SIDM, for further dissemination to their members. Copies also may be shared with companies which are already there in the database and have the product that we are interested in. In classified cases, the distribution of these copies would be restricted. The objectives are very clearly laid down in the RFI, and the aim is to identify potential lessors of that particular product. The reply of the vendors concerned helps in formulating the letter of request, which would be the next step thereafter. It generates the inputs for the RFP, determines the indicative budgetary and cost implications which are important. It determines the conditions precedent. We had a look at it previously as to what the conditions precedents are, which are to be satisfied both by lessee and the lessor before the lease agreement comes into position. Adequate time is given to the vendors for a structured response and interaction may be planned by the empowered committee, may be formed for that particular issue of lease. RFI should indicate the type of assets, the capabilities sought, the quantities that are required, the type of lease, maintenance there, not there, whether his lessor's manpower will man it or whether our manpower will man it, etc. Schedule delivery dates, lease term including early termination or extension options, delivery/redelivery locations, delivery conditions, what are the minimum life required of that product before it comes to us, compliance certification to all the stipulations, delivery inspection procedures have to be worked out and they have to be followed at the time of delivery. What is the insurance requirement? Rent, deposit, what is the commitment fees for the lessor to take it off the market, the payment made by the lessee, other payments related, maintenance, compensation mechanism in case the maintenance is being done by the lessor, maintenance, operations and records as to how they're going to be carried out and what records are to be put, pre-post delivery modification and cost sharing of such modifications. We had a look at it during session 1. Conditions precedent, definitions of key terms applying in the lease, regulatory registration regime governing law of our country as well as the country from where the lease is coming through, confidentiality related to the product, especially in terms of the modifications that may be carried out for Indian conditions, also the kind of technology being put by the lessor, which has got technology in control of the government, into the product asset that is being provided to Indian military, tentative time schedule and the leasing process to be followed. After the extensive interactions with the vendors concerned and all stakeholders, the identification of the equipment and operational demonstration if required is carried out. Now, identification of the equipment is based on the response to the RFI and the various interactions that have been held, and the SHQ will identify the suitable equipment and also finalize the list of the potential lessors. This list and the approval of the equipment is done by the principal staff officer at the service headquarters levels, respective deputy chiefs concerned. Now, operational demonstration may be required in certain cases where the equipment performance is not checked before. This operational demonstration may be dispensed with if the operational performance of that particular equipment is known, either it is in use with the services or was used in the past. Performance or utility of this equipment has been observed during exercise or in multilateral events. It may be the operational demonstration may be dispensed with. Following the identification of the equipment and the vendors from which this equipment can be leased, a lease operating requirement LOR is made out. It defines the operational capability sought and any special conditions of lease. A similar thing like PSQR or SQR. However, it cannot be futuristic in nature. It is based on the capabilities of that particular equipment that has been identified and is available for lease. This is also ratified by the Special Equipment Policy Committee, which is also responsible for SQRs in the normal procurement cases. The next step is taking the acceptance of necessity. Now, for the purpose of the acceptance of necessity, a statement of case has to be drawn up and circulated to all the stakeholders concerned. In the statement of case, a cost-benefit analysis is carried out as to what would be the cost of an outright procurement vis-a-vis the leasing undertaken. Also, the issues of time considerations for the purpose of leasing vis-a-vis the procurement time consideration is included. The AON is sought based on the total value of lease, which includes the insurance cost. And if maintenance has been carried out, also the maintenance cost of the maintenance is being given to the lessor concerned than that cost. Validity of the AON is 6 months from the issue of the minutes of meeting of the AON according authority. And wherever the RFP is not issued within 6 months, the AON would lapse. In this case, the service headquarter could seek fresh AON with justification as why the first AON was not issued out in time. Now, at times the RFP is issued in 6 months. However, it is later retracted because of any reason. In this case, the AON remains valid provided the original decision remains unchanged and a new RFP can be issued out within the periods not exceeding the 6 months from retraction. That means another additional 6 months from retraction is provided as per the stipulation of the original AON. The broad details of the project are hosted in the MOD and the SHQ website within 1 week of the minutes of meeting for AON. And additional vendors who did not respond for RFI and therefore have not been given and would not normally be given the RFP concerned, therefore they can request for the RFP. Lease cases being progressed with DPSUs or under the intergovernment approval route with the foreign government are not treated as single vendor cases. For AON authority, up to rupees 500 crores, the Defence Procurement Board is the AON authority on recommendation by the Services Procurement Board. Above 500 crore, the Defence Acquisition Council on recommendation by Defence Procurement Board. Further steps in the procedure for leasing remain the same as that for a normal procurement. The next step is the solicitation of our offer, which is nothing but the RFP being issued out. Then the technical evaluation committee considers the product and the reply of the RFP in terms of the technical consideration. no trials are held of this thing. I told that there could be operational demonstration. However, if the equipment is known, performance is known, no requirement of even the operational demonstration, and therefore no staff evaluation is required. The contract negotiating committee comes in between, and there would be an approval by the competent financial authority based on the financial power, and therefore instead of a contract would be a lease agreement that would be signed, and in case of post-contract management, there would be a post-lease management, which basically means the same thing. Review powers in terms of delay. With the delay in identification of the equipment, the operational demonstration is being carried out. After receipt of the RFI response is more than 24 weeks. In delegated power case is the PSO concerned. In the non-delegated powers is with the DG acquisition. If there is a delay in formulation of the lease operating requirements by more than 24 weeks after the identification of the equipment the operational demonstration, then the case goes to the PSO the DG acquisition. Delay in formulation of the lease operating requirement by more than 52 weeks, then it has to go to the Defence Procurement Board in non-delegated cases to the Defence Acquisition Council. If there is a delay in fielding of the case for acceptance of necessity more than 24 weeks after approval of the lease operating requirement, 24 weeks goes to the PSO or to the DG acquisition in non-delegated powers. If the delay in a similar thing is more than 52 weeks, it has to go to the Defence Procurement Board the Defence Acquisition Council. And if there is a delay of approval of the competent financial authority beyond 8 weeks after submission of the contract negotiating committee report, then either in the delegated powers it goes to the PSO, in case of non-delegated power to the DG acquisition. Certain important clauses in the lease contract. The title to the asset, including its registration, will remain vested with the lessor during the period of contract. Lessor, however, will not interfere with the use of the asset by the lessees within the provisions of the contract. The effective of the date of contract is the date of signature or the date of delivery from the date of release of advance payment by lessee to the lessor, provided documents are submitted within 45 days of contract signing. If the documents are signed and submitted, then the date of release of advance payment to the lessee becomes the date of from where the delivery dates shall commence. If no advance is paid, then deliveries reckon from the date of contract. Advance bank guarantee. The period exceeding the period of delivery of leased equipment by 3 months. That means whatever period the equipment has been leased, by 3 months more the advance bank guarantee has to cover. Now in case of a finance lease where the complete cost of the product is being taken in terms of the lease agreement that being paid over a period of time, in that case, and the ownership right after that may be with the MOD, in that case advance bank guarantees may not be required. Premature termination clauses could be by mutual consent, also by the non-defaulting party in case the contract is breached and not cured within the laid down cure period. That is whatever time interval that has been said that the equipment will be repaired, rectified, etc. It has not been done as per the contract provision. The non-defaulting party could ask for a termination in contract. On event of a total loss or improbability of repair by the authorized service facility within 60 days, the contract would be considered as prematurely termed. And the asset value by the lessor is to be paid within 30 days of contract termination. Usage limits will be laid down in the contract. These could be in terms of hours, in terms of kilometers, which also could be in terms of per day, per month, per annum. Performance metrics have to be laid down in the contract which are required to measure satisfactory performance of the asset over its complete lease period. In the course of the last two sessions, we had a look at the lease chapter 9 of DAP 2020, An important aspect which can lead to gaining of high technology, low volume products which are to be utilized by the Indian military, also to use it to gain experience before going in for its procurement. Important issue, there are major encumbrances in the complete issue, things like maintenance, payment terms, insurance, return of the equipment in the required state, the performance metrics of the particular equipment. But all said and done, it leads to capability enhancement without going through the complete procurement cycle, which may be time consuming. And especially in times where it may be critical, it becomes an important chapter to exploit. There would be objections by the foreign government, and there may be objections to by the foreign government in using the particular equipment in particular circumstances. All these challenges have to be overcome when undertaking a lease agreement. We shall now come to chapter 6, the standard contract documents. I must admit to you that I find it very cumbersome, but an extremely important issue, because should you not frame the contract document in the proper manner, should you not even as a vendor be able to interpret the contract document in the proper manner, there would be hurdles in the post-contract management. And I have seen contracts falling after the contract has signed. Till then, it's been a pleasure being with you. Thank you so very much.